Hello everyone, welcome to the Lawcast. My name's Melanie Thorley and this is Chris Santana.
How are we all going?
We're all good and we're solicitors of MJT Law. And this is eBay once again. eBay has been a little bit demanding today, so we'll... Excuse me. We'll keep trucking on. So, anything new
No,
in the zoo?
Not a whole lot, Lou, in my sphere. What about you?
I would like to say to everyone that I am right. I like being right, and I was right.
You are right. You picked what was going on with the government well, and you looked through the
That's right.
cryptic messages in all their interviews.
Yes.
They never really straight up with something. They'll just...
I was right. Yeah, I like being right, everyone. For those who don't know me, I do love being right. Lawyers love being right. So what I'm right about is this mandatory vaccination question.
Yeah.
And what I said weeks and weeks ago was that I thought it was lawful for almost any industry to impose mandatory vaccination on their employees. And I was quite happy to provide both alternative views, but it turns out through the Supreme Court,
Yeah,
New South Wales, it's concluded that I was right. Whoopee!
Yeah, so I suppose for everyone out there was a challenge from a number of different employees from different areas of the public sector in New South Wales who had been mandated to get the vaccine, and they put in a class action.
They did.
And they lost.
They did lose.
They lost, and I'm not certain whether it was a joint judgment or it was a single judgment.
I think it was a single judgment, but yes, they concluded that it was perfectly lawful to mandate. But what I'm also like being right about is that I think a few weeks ago, I take a lot of calls on this question, and I give my legal advice. I do not provide a personal opinion or a medical opinion or anything like that. But I did say to an employee that I believed that notwithstanding mandatory vaccination in industry, there is a wave coming. And at the beginning of that wave, what was happening at that time was we had just had Victoria mandate vaccinations for almost everybody. And we talked about this. And I said the wave was coming. And the next thing we knew is that Tasmania shut their doors to anybody unvaccinated. Yep. Then Western Australia said anybody incidental to the energy resource industry needed to be mandated vaccinations. And now South Australia has just announced that they're going to shut their doors to anybody who is unvaccinated. And we've also found out today that Aldi, Coles and Woolworths are requiring all their entire employees to be vaccinated. Now, there's a slightly separate thing with Coles from memory of the reading of the material.
They're sticking with along the lines of
New South Wales, Victoria,
the governments that have actually mandated. They're sticking with it.
But Aldi and Woolworths are just saying everyone. So that's actually, there is a way I think coming. And look, whatever our views on vaccinations, I think those who are choosing not to be vaccinated are going to find it harder and harder to move around, to attend venues, to do all these things. And I think the world's changing.
And if we bring it back into the employment sphere, it's most jobs require travel.
Yeah.
And it's not. We're not talking travel as in a truck travel.
No.
Even as a lawyer, I travel
across town
from time to time
into court. Yeah, we leave our desks and move somewhere.
And it would become an inherent requirement of my role as soon as a court or you can foresee a situation where the government says that if you want to be in a government building, courts, departments of transport, things like that, you need to be vaccinated. And just like that, it would become a requirement of my role. And
well, it's not going to take long for, say, New South Wales or Victoria. Victoria's already done it, but it's not going to take so long for New South Wales. And there may be a time where you have to attend court in another state.
And if I can't travel there,
it's just going to become really interesting. So yes, I'd like to tell everybody that I like being right, and I was right. I was right. I mean, I know it's a very strange subject to be right on, and it was not particularly difficult to be right, but it's still. I'll take the win where I can get it.
No. It's I'll admit that when it wasn't certain, I was on the other side of that advice, and
But lots of practitioners were. You weren't alone in that view.
It was when the times were a lot more uncertain to them, and
I called it very early. Yeah, very, very early, and I could have been wrong. Yeah.
But I think you'll find you're right that there may be a few rogue judges here and there, and we have seen a couple. And there is a particular decision which is a
Fair Work Commission.
A Fair Work Commission decision, and they were incredibly scathing. This particular commissioner...
There was a mandatory flu shot from memory.
Yes.
Yes,
and
he was.
Obviously, they brought the COVID vaccine into it. And they were incredibly discouraging.
They were.
That represents the
and everyone
outlier.
went, but it's an outlier.
Yes.
It's an outlier, people. But yes, I really, this is about me being right today. I'll take the small one.
Take it.
But there was recently a different case. This is a high court case, and this is an academic, a professor at a university, who was fined for serious misconduct as he questioned the impact of climate change on the Great Barrier Reef. And this is fascinating, because this is a little bit like academic privilege, I guess.
Yeah, the ability to write what you want and freedom of speech, essentially.
And James Cook University, head of physics, he emailed a journalist. So it went.
So what did he do?
Well, I'm just reading it here, people. But yeah, it says here that Dr. Ridd was employed by James Cook University, and he emailed a journalist questioning reports about the degrading reef, suggesting they weren't reliable, and raised issues in relation. The issues and ideas raised in the email related to his field of expertise, and they were honestly held opinions, were not unlawful or defamatory, but they didn't. I don't think they passed what you would call the pub test. You know, they had all those policies in place that talked about intellectual freedom protected by the enterprise agreement and so on and so forth. But yeah, this is really interesting, because this talks to what, you know, climate change skeptics and all this sort of thing. And we know at the moment our government is in the midst of a disagreement with their own party as to how climate change is going to be dealt with moving forward. I'm just really interested to see how the whole thing plays out, because while I was watching the news this morning, I said to my husband, I'm a climate change believer.
Okay. I mean, if that's the flip side to skeptic, sure.
Yeah, I'm a climate change believer. I believe climate change is happening, and I believe that we need, as a world, to be changing our ways. And I'm, like, anybody who knows me knows that I, recycle.
You're very interesting.
I'm very,
You ride to work,
I ride my bike to work. I not just recycle things, I upcycle things, I reuse, I use them till they're dead, so on and so forth. And it's this kind of fascinating to me that this academic's out there, and he was terminated for holding the view. Was
he terminated for a breach of a policy?
He was. Breach of code of conduct, failing to treat others with respect and courtesy in a public discussion. And
right, so there's actually, it's not the view. It's not the view, it's the way he said it.
Yeah.
Or what he was doing.
Now,
because we see it, in a lot of employment contracts, which are, that you're to act courteously.
Well, yes, but this whole thing went to the High Court.
I have actually read quite a few of the cases leading up to it.
Yeah.
And he had lost twice.
Yes.
But, he is pressing for it.
I think, like it says here, that the court found that the first censure and part of the basis for the final censure was unjustified, but because it was a all or nothing basis, they had to hold it to be a fair dismissal. Yeah, I guess so. In all, it says here that Dr. Ridd ran his case on an all or nothing basis. The termination for the decision was justified on the reliance upon conduct. They were subject to the misconduct findings not protected by intellectual freedom clause. But you've been watching this case.
I have been watching it, and it actually has gotten quite a lot of political sort of attention, because as you can imagine, it gets tired and gets sucked into the climate debate. And the real attention it got was the idea that someone isn't able to, views are being clamped down on.
Yes.
And I think the outside noise really loses sight of what those types of policies and what a breach of a policy generally is. It kind of failed to take into account the fact that when he breached it, he knew what he was doing, he knew his obligations under it, and nevertheless did it. And it's the idea of being belligerent and being, just completely disregarding what the views of that particular university was. And they never really said to him that he can't say it. It was more in relation to the way he was doing it and how kind of open to the world he was being.
Right.
They also kind of mentioned that it's
because it becomes part of the university's story too. That's the problem, right?
And they really, some of the outside knowledge didn't really touch on the fact this actually applies to everyone. Although the idea of being fired for intellectual freedom is, from what I really can tell, is only applies to academics. So I don't know how that would apply to anyone else.
It's very narrow.
But it still goes to the idea of kind of what you say in the public domain and how that reverts back into your employment.
This is really interesting. Social media, what happens next? For those who don't know, we are about to be part of a seminar, and part of the seminar is us talking about social media and the impact it has on it. And this is a really interesting one. I like the idea that employers can control their own story, because why shouldn't they? It's their business. Employees are, let's say business lasts 40 years. You're going to have not the same employees for the entire 40 years. It's a little like civil service. The civil service maintains, or the Secret Service, and it maintains no matter who is in power. And I think it's important for the company to be able to control their story. And if there is a point of view that the company is taking, and we've talked about this in the past, their ability to be able to give their own values to the business. If there is an employee who promotes an interest outside of the values of that business, I think there should be policies in place to prevent that sort of thing.
And a lot of it comes back to the how these sort of things get reported. So if we take it to an academic, if he makes a comment on a particular issue, let's keep it to climate change, what it will be reported as, it will be James Cook University academic, lecturer, blah, said this.
Climate change skeptic, and they overblow it.
Your views become views of the organisation, and that is going to happen for almost everyone. And really, it's part of what you buy into.
Yes.
You really have to take a broad view of what it is to join an organisation. You buy into what they're talking about. And something that he potentially failed to take into account was when he was working there, in return for the remuneration that he was receiving, he was, you buy into the other obligations, and one of them was to keep to the story. And they weren't asking him to say things that were contrary.
No.
There was no obligation for him to say that.
To have a different view.
To have a different view. Just if you have a different
Cool
view,
your jets, dude.
Cool your jets. And you know what? I think fair enough.
Yeah, okay.
I think fair enough. And look, he's probably going to take it pretty harshly.
Well, this is it. It's done. The High Courts can't go any higher. So those who don't understand or haven't really thought about the system here, High Court is the last court to go to. There's nobody else to complain to after you get to the High Court. You might start in a district court, you might start in a lower federal court jurisdiction, you go through the court jurisdictions, and then the last place you can go is the High Court. Once the High Court makes a decision on something, there is nobody else reviewing that decision. There's no appeal decision from the High Court. So this is the end for him.
And look, he might continue it in the public domain, and he'll fight the, freedom of speech. But I don't know about you, but I take a very different view on what it is to have rights or freedoms. I take a view that, technically speaking, you've got a right to do whatever you want. Okay. You have a right to do everything in that is humanly possible, including things that are completely unethical and wrong. But equally, there are...
You don't have a right to your freedom if you murder someone.
Well, you've got the freedom to do so, but there are freedoms which... there are rights which can come against you. For example, their ability to be punished.
Yeah.
And in this particular case, he has the right to speak what he wants, but he also comes with it consequences. And you've got ultimate rights and freedoms. Doesn't mean there isn't consequences. They're not mutually exclusive, not in my eyes.
Well, for those of you who are friendly towards this chap's views, then it's a sad day for them.
Yeah,
for those of you who feel the same way as Chris or I do, it's just another step in the process.
Yeah. But I've got another case.
You've got something else going on.
And it's...
You come up with the weird...
I come with the weird cases.
We had the urine one a few weeks ago.
The urine one? That lady down in the Gold Coast. But this one is involves in Victoria.
Okay.
And it involves a chap who was under investigation for harassment, bullying and harassment.
Okay.
And the case, I think, represents a bit of a rock and a hard place for a particular organisation. So he received 2 investigations, and he received reports about the investigation to him in order for him to respond to.
Right, so he had allegations
put to him.
Yeah.
Now, in the report put to him, there was redactions. Now, the redactions were explained by saying that they were to protect those who were making the allegations against him.
Okay, they didn't choose to just rewrite the report without that part in it?
For whatever reason, they didn't do so.
Okay,
so
it's fine. They just took the report, redacted, and gave it straight to him.
Yep. Now, they may not have had an opportunity because he actually filed the application on the procedural grounds.
I see. So it became something that they had to be
determined.
Provided. Okay.
And he ended up being successful.
Successful in what?
In his application to essentially be afforded procedural fairness and be receiving a full report in order for him to respond to. Now, the court found that essentially by not providing him all the details, they didn't have all the information in front of him in order to adequately respond. Wow. And on one hand, I understand that. I understand it as a general principle. But then on the other hand, I also think the organisation was really trying to do the right thing. They weren't trying to rob him of the opportunity. They were really just trying to probably stop reprisal or embarrassment, or really trying to protect the complainants in a way which would encourage others to do the same at a later time. And we're hearing lots of noise about employers making sure that they do, they take steps to protect.
Someone who's complaining about harassment or bullying doesn't want their entire story to be told again on a piece of paper to the person, so they can sit there and pick it to pieces and continue to bully and harass that person.
That's exactly right. And the courts now found that you can't. You really do need to put it and particularize it to that particular employee. And
so what's the answer here? I mean, is it an outlier? Is this one of these outliers we've been talking about?
I mean, maybe this is the Victorian Court of Appeal, so it's pretty high up. But I don't know. What do you think of the idea that essentially that employer is caught between a rock and a hard place?
Oh, look, I think the employer could have provided the allegations to that person without providing the report. Because what you're saying is you need to provide whatever investigation you do, that person needs to receive it.
Yeah.
Now, there are ways to present a report or write a report that doesn't provide everything.
So it's
you know, you could have the witness statement and then write a report. You don't have to put the entire witness statement into a report, which seems like they could have possibly done. Look, it could be an outlier, because it could have been based on, I haven't read the case. It could have been based on the fact that there was no names or no dates, so the person couldn't go, oh, it was this person.
Yeah.
You know, if you're saying you called somebody a stupid head and it's inappropriate, and if you're doing that all the time, how do you know who complained?
Yeah.
Do you know what I mean? It's I don't know.
I'm interested to see where this case goes. You know, it may go somewhere, and some commentary that comes after it, because I think it's one that, you know, really leaves it in the lurch.
I think it's going to make it hard for employers to protect the complainant at the same time as provide the person who's done the offending, alleged offending, a chance to respond. But in my view, the only thing that is required is to properly particularise the complaint in order for the person to be able to identify properly what's going on, so they can make they can put a response in, and that response might be, I didn't do that, or that response might be, this was actually the story, this is what actually happened that day, but enough to be able to set that person's mind back. And maybe actually the problem is it just didn't do that.
Maybe. I mean, one of the allegations which were put to him was that he was inappropriately accessing, looking up specific customer details. Well, not customer details.
What?
Searching. You know, when you're in the sort of police force or any of those things, looking up people that you shouldn't have, or if you work for a bank, you're not supposed to be looking
at people's bank details.
That you know, for example.
Yeah.
And you can imagine, you know,
happens on TV all the time. They call up a mate, hey mate, can you just look up this guy? I just want to find out, you know, where they went yesterday.
And so if you think about a bank, the allegation is put that you've been accessing inappropriate searches.
Right.
And let's just say,
because it happens in real estate as well. You're not meant to be using your real estate license thingy to look up everybody's, you know, what do next door neighbour pay for their house, sort of thing. You're not meant to be doing that.
Not supposed to be doing
or
that.
Who owns something if it's a rental, stuff like that.
So, I mean, take that real estate example. What happens if the person for which you were searching is also an employee, and that employee is also the complainant? Because you can imagine, how are you going to particularise that report where they may do hundreds of searches, and you say you've done one that was inappropriate, and then the natural question is which one?
Yeah, I think there is a way to do that. You can either identify all of them and write the list, or identify a reasonable portion of them. You know, you could probably say you accessed A, B, C, D, E, F, G, H, I. Further, you know, this is not an exhaustive list. We can provide you an exhaustive list if requested. But this is an example, and what we didn't want you to do was access stuff like this. This is the big example. You know, and then, you know, up to the respondent to make a call as to whether that's enough information for them to go, oh, I can see where they're going with this. Do you know what I mean? It doesn't. You don't necessarily have to give the entire list. But we've had that before. We've had people given, been given entire lists before, and it's like 500 pages long, and we've been given a portion or a selection of the list.
I wonder if.
Sorry, eBay's looking. So naughty.
I wonder if.
Good girl.
Almost. What the redaction is almost a lazy way of governing an enterprise. And what I mean by this is...
Look, I don't think they should ever... I would never say to an employer, hey, look, what you should do is take the entire report, redact it, and hand it over. That is just asking for trouble.
It is asking for trouble. And I just think being able to redact it is trying to protect against reprisals. But that in of itself is something that shouldn't be going on, and definitely a reason for dismissal. So what I think is, instead of redacting...
What are you doing? You're a crazy dog.
Instead of redacting it, just govern what's there. If the person, starts contacting the complaint, that they're out. That's an absolute reason for dismissal.
Well, this is it. I think...
Or, if they're not keeping it confidential, they are, so-and-so made a complaint about that is absolutely a reason. And that in of itself, govern the problem, not trying to get on the front foot.
Yeah, I think... Notwithstanding, it is really hard for employers to get it right all the time. And there's such an onus on them to do that. It's really... And we've talked about this in terms of underpayments and things before. It's just... The awards are like landing the space shuttle into the Hudson River.
Yeah.
How do we navigate these really tricky awards and ask the employers to get it absolutely right all the time? And the penalties for not getting it right
so grave.
Are so appalling that we want to leave it to the hardcore offenders. But how do we know that they're just not wrong?
One of my the way I see it. Laws that don't work, or they're not fit for purpose, is I don't believe inadvertent breaches of any act, whatever it may be, should incur significant penalty. If someone, we shouldn't be bringing it into situations where they pretty well did everything wrong, they just interpreted one particular thing wrong,
or just got really bad advice. We know the ATO don't care if you get bad accounting advice.
No.
So I guess we're looking at it from a personal perspective. But wow, it's tough to get it right as an employer these days, and the laws are only getting more complicated.
Yep.
There's no two ways about it.
And the onus is on being able to put on multiple masks or put multiple faces.
Absolutely.
It's hard.
Look, all I can say is, as in interpreting employment law, I'm glad that this is the only thing we do, because I can't imagine doing this and doing something else and it not taking up all my time already. Do you know? I don't know how.
It is such a specialised area.
I just am glad that we don't have to do employment law without doing something else at the same time. I just couldn't imagine it.
All right, well, I think that's
for the week. Thank you very much, everyone, and hopefully you'll all agree that I like being right.
Who doesn't really? I know people say you shouldn't gloat, but
No, absolutely. We're good at what we do, and we should take the wins where we can get them.
Yeah.
For goodness sakes, we know we get enough difficulties in this.
People will tell you when you lose. They don't tell you when you win.
They do tell us when we lose. We're not losing even when we don't agree with them. They tell us.
You don't agree that you've won. That's fair enough.
I'm going to take the wins where I can get them.
Enjoy it for the next 2 weeks.
I'm going to enjoy it for the short time that I'm going to have it.
Till the next issue, right?
Till the next issue, everyone. We will come back. Thanks for watching the Lawcast.
See ya.